scheme of the division between the civil process and the criminal process, and a clear distinction should be maintained between them. Moreover, we were reminded that the courts have a well-established aversion to litigious challenges to the process of court, ostensibly to paralyze the progress of a given case, in what has come to be known under the rubric of the Stalingrad defense. Further, we were directed at the remarks of His Lordship Mr. Justice Wallace in the Moyo and Sonti case. We emphasized the critical text in that matter. Why are the issues germane only in the context of criminal proceedings being canvassed and determined in civil proceedings, and not in the constitutionally compliant forum and in accordance with the constitutionally compliant statute provided for the adjudication of criminal cases? Unquote. On the other hand, there is clear authority for the contrary proposition that a party who is charged by a private prosecutor may indeed approach a civil court for relief, as is sought in this case. The case of Solomon versus Magistrate Pretoria, a 1950 decision in the Transvaal Provincial Division, is the first of several decisions cited to us which indicate that that is so. After having considered the contentious contention, the court in Solomon addressed the proposition, and we emphasized the critical passages in that judgment. No doubt the sections referred to do bestow a right to prosecute, subject to the necessary conditions. But I cannot take the view that the fact excludes the jurisdiction of the court to interfere on proper cause. If Mr. Retief's contention were correct, this court would have no power to intervene, even though it was shown in the clearest possible manner that the party who had instituted the private prosecution had no interest whatever in the outcome of the trial and embarked upon it for an ulterior motive. In such a case as I have postulated, therefore, this court would be, in my opinion, by virtue of its inherent power, be entitled to set aside a criminal summons issued by its own officials or to interdict further proceedings upon it. It is also by virtue of its inherent power that the court interferes to restrain illegalities in inferior courts, either by way of interdict or mandamus or by declaratory order, as it has on occasion done. Since then, this proposition has been affirmed in the constitutional era in Van Deventer versus Reichenberg in 1996 in the Cape Provincial Division, in Nedbank Bank versus Ilitrana, a 2004 decision in the Southeast Cape Local Division, and in Nundadal versus the Director of Public Prosecutors, KwaZulu-Natal, a decision given in 2015 in the KwaZulu-Natal Provincial Division. It is therefore plain that upon such authority, Section 106HA of the Criminal Procedure Act cannot be construed to be the exclusive route by which a person aggrieved by a private prosecution can challenge the title of a private prosecutor. Moreover, the proposition advanced about avoiding cross-contamination between civil courts and the civil process and the criminal courts and the criminal process is overstated. In truth, there is no substantive distinction between a criminal court and a civil court. There is only one court, and the streaming of criminal cases and of civil cases to different judges is merely an organizational convenience. There are no distinct jurisdictional competences. Ancillary thereto, it follows that the process of such a court is also seamless. No question can arise of a trespass into the work of another court with a distinct jurisdiction. It is in these respects that the present case does not evoke the suspicion posed by His Lordship Mr. Justice Wallace in the Moyo and Sonti case. Accordingly, to sum up, the notion that the only route for relief a party can invoke to contest the title of a private prosecutor is to raise the question of title as a plea, as mentioned in Section 106H of the Criminal Procedure Act, is misconceived. In any event, the very appearance of the applicant before the criminal court is what is sought to be prevented by the relief sought in this urgent application, which is premised on the contention that to appear in a criminal court per se would be to submit to an unlawful intrusion on the rights to freedom of the applicant, if the private prosecution is unlawful for want of proper authority. Herein lies also the key factor that demonstrates the urgency relied upon in this matter. The trial date is 19 January 2023, less than a week away. There were other grounds of urgency relied upon initially, but one alone is sufficient. It is axiomatic that if the aim is to avoid having to appear, even if merely for a formal postponement, the matter before this court is urgent. To reiterate, the nub of the applicant's case is that to submit to the summons is a violation of his rights to freedom, because it is an unlawful summons issued by a person without title to prosecute privately. It is alleged that the urgency is self-created, but the premise for that contention is specious, to say the least. The papers detail the progress of the parties' exchanges from the moment the summons was served. First, there was an exchange about a defective summons. The respondent denies the defect, but chose in any effect on the 21st of December 2022 to file a further summons attaching the nolle prosequi he relies upon, this act being described by him as supplementary. This matter was enrolled for hearing on the 10th of January 2023, 20 calendar days thereafter. There are no grounds for criticism evidenced at all. The critical question for decision is whether there is an apparent right, even if only prima facie, that is threatened. Again, there is a plethora of contention in this regard. However, again, shorn of the details and nuances in these over-lengthy papers, the prima facie case which is shown is straightforward. In our legal system, the only agent that can lawfully bring a criminal prosecution is the state. The National Prosecuting Authority is the organ of state that manages prosecutions. There is an exception to that exclusivity. In a specific case where the state declines to prosecute a party against whom an aggrieved person has lodged a complaint with the police, a certificate may be obtained from the National Prosecuting Authority to open the door to a private prosecution by a person who can show that they were harmed by the commission of the alleged crime set out in the police complaint. That certificate is usually known by its Latin name, a nolle prosequi. The process is closely regulated by Section 7 of the Criminal Procedure Act. The relevant portion of that reads as follows. In any case in which the Director of Public Prosecutions declines to prosecute for an alleged offence, a private person who proves some substantial and peculiar interest in the issue of the trial arising out of the injury which he individually suffered in consequence of the commission of the said offence, may institute the conduct of a prosecution in respect of such offence. No private prosecutor under this section shall obtain the process of any court for summoning any person to answer any charge, unless such private prosecutor produces to the officer authorized by law to issue such process a certificate signed by the Attorney General that he has seen the statements or affidavits on which the charge is based, and that he declines to prosecute at the instance of the state. Accordingly, the authority to conduct a private prosecution is one granted to a private person within the four corners of the nolle prosequi. No person is required to subordinate themselves to a private prosecution except where the state has issued a valid prosequi which relates to a crime allegedly committed by that person. A person who, in the absence of a nolle prosequi relevant to the given person, issues a summons to bring that person before a criminal court, violates that person's rights to personal freedom. There may be several other respects in which such a person's other rights may be further violated, but key to any expression of any relevant right being violated by an unlawful private prosecution is that of personal freedom, which is a right guaranteed by our Constitution and implicated in sections 9, 10, and 12 of the Constitution. These are the sections which guarantee equality, dignity, and freedom and security of the person. Furthermore, part of the argument advanced by the applicant also invokes the right to just administrative action, as dealt with in section 33 of the Constitution, as shall be alluded to hereafter. In this case, the title of the respondent to bring a private prosecution against the applicant is challenged on a number of grounds. The critical proposition is that the nolle prosequi upon which the respondent relies is neither inapplicable to the applicant nor is lawful, and if it can be properly construed to indeed be applicable to the applicant, the nolle prosequi itself is unlawful. Some of the legal issues which are raised are novel. We list the issues which a court in due course shall have to decide. Does the text of the nolle prosequi, properly interpreted, relate to the applicant? Is the text too vague to be a valid certificate? It is contended that a nolle prosequi should name the persons who the National Prosecuting Authority decided not to prosecute in order to be valid. On these papers, 2 nolle prosequi were issued. The first named Advocate Downer. Upon demand to the National Prosecuting Authority by the respondent, who wished to also charge Miss Morn, a revised document was issued omitting his name and stating any person. Whether a revision in this form is proper must be decided. It is claimed that because the charge levelled as an accessory after the fact or of obstructing the course of justice is a crime that could be committed only after the principal crime had occurred, and the nolle prosequi refers only to the date of the principal crime. Ergo, the nolle prosequi could not have contemplated a crime by the applicant. The author of the nolle prosequi, the National Prosecuting Authority, has denied, for what that is worth, that it related to the applicant. Whether what the author states is relevant or admissible is itself contested. The National Prosecuting Authority are yet to answer fully in this case, and it has indicated that it shall do so in relation to Part B of the relief sought. The question of whether or not the nolle prosequi can be interpreted to include the applicant depends in part on whether the police complaint mentions the applicant as contemplated in Section 7.2 of the Criminal Procedure Act, which I cited above. It is common cause that the applicant is referred to in the formal complaint, but the significance of that reference is disputed. The respondent contends that the mere mention of his name is enough. The applicant's case is that the mention of his name is not in relation to a complaint articulated against him, but rather mere narrative, which alludes to the fact that the applicant was conducting an inquiry into the publication of confidential information. It is contended that if that is the correct import of the reference, the applicant is not included as a potential accused in the police complaint. It is contended that it is not apparent that the state ever applied its mind to the crimes of which the applicant is now alleged to have committed, and thus, having regard to the provisions of Section 7.2 of the Criminal Procedure Act, the nolle prosequi could not be understood to refer to him. As already stated, the National Prosecuting Authority have yet to file an affidavit. The applicant contends that the issue of such a nolle prosequi being administrative action required that he be afforded the benefit of audi alteram partem as contemplated in the Promotion of Administrative Justice Act in order for it to validly apply to him. It is common cause that the applicant was not afforded a chance to be heard before the issue of this nolle prosequi. There is authority in Nandedal, the case referred to earlier, for the proposition that the issue or refusal of a nolle prosequi is indeed administrative action. Whether audi alteram partem is indeed a requirement for the issue of a nolle prosequi is a novel issue which has yet to be decided. Lastly, is the actus reus alleged, that is to say, neglecting to respond effectively after having been asked in his capacity as President of the Republic to cause an inquiry to be launched into the conduct of the National Prosecuting Authority and of the media for publicizing confidential information, actually a crime? If not, it is argued that no nolle prosequi could be validly issued in respect thereof. Implicated herein is the question of whether or not in our law, state officials who are neglectful of duties are liable to criminal sanctions. The respondent contends that they are. This is a proposition that is both novel and radical, with extremely wide-ranging implications for the entire state apparatus. Were one or more of these grounds challenging the validity or applicability of the nolle prosequi to be established at the forthcoming hearing, the result would be to invalidate the summons served on the applicant. What is sought by the applicant is a chance to do precisely that. None of these claims, which I have read out, are implausible on their own terms, even if they are ultimately found to be incorrect or inadequate to invalidate the private prosecution. Therefore, in our view, a prima facie case of a right to personal freedom being violated has been shown. Next, is there any material harm? It was argued that the harm of appearing in a criminal court on the 19th of January was not material. This contention misses the point. The harm lies not in the temporary inconvenience of physically attending a hearing, if only for a formal postponement. The critical harm concerns a fundamentally, constitutionally guaranteed right to personal freedom. That value, which is foundational to our constitutional order, may never be treated lightly. Our history instructs us that it is a matter of pride that South Africans value and assert our freedom above all other considerations in the face of whatever adversity we chance to meet. Our law must guard that right and its exercise unreservedly. Among the contentions advanced why the threshold for an interdict has not been cleared was that of the decision in the outer case. It was said that this case applied to a decision taken by a private prosecutor. The outer case had held that where it is sought to interdict a statutory authority from performing a function within its remit, a higher threshold existed than when seeking such relief against a private litigant. This approach safeguards organs of state from being paralyzed by litigation which might damage the broader public interest. Thus, in terms of the outer case, only in an exceptional case should an interdict be granted against an organ of state. The contention advanced to us was that a private prosecutor exercises statutory authority and must be treated alike. This is not correct. The respondent's contention is untenable. The legislative scheme in terms of which the statutory authority in which the power to conduct the prosecution of persons is vested, and in a given case declines to prosecute, must not be understood to be a delegation of statutory authority to the private prosecutor. A private prosecution is properly so called, private, not public. The outer case cannot be applicable. Is there a viable alternative to relief in the form of an interdict? In our view, plainly, there is not. This we take to be axiomatic, as it would require the applicant to appear before a criminal court and by so doing implicitly submit to a process which he claims is unlawful. Were the applicant to succeed later to have the private prosecution declared invalid, the harm of the submission to unlawful action cannot be undone. As to the balance of convenience, the respondent suffers no harm if there is a delay in the private prosecution in order to debate the controversies alluded to in this judgment. As mentioned earlier, the trial of the alleged principal offenders has yet to begin. Their conviction is a necessary condition for criminal liability by the applicant. The costs of this application were hotly debated. However, it is unnecessary for us in this urgent hearing to address that question, which shall be reserved for a decision at the hearing of the main case. It is for these reasons that an order will issue in the following terms. 1. The application is urgent and the ordinary forms and service provided for in the Uniform Rules of Court are dispensed with. 2. Pending the final determination of Part B, the first respondent is interdicted from taking any further steps to give effect to the nolle prosequi certificates of 21 November 2022 and 6 June 2022, and the summonses issued by the registrar on the 15th and 21st of December 2022, or to pursue the private prosecution under case number 59772 of 2022 against the applicant in any way. 3, the costs occasioned by this urgent application shall be reserved for decision at the hearing of Part B of this case. 4, the parties' representatives are directed to immediately approach the office of the Deputy Judge President, Johannesburg, to arrange a case management meeting to set an agreed date for the hearing of Part B. We hand down this judgment, which will be uploaded online within the hour and emailed to such parties as who require that. Court will adjourn.